In re Rachel L. confirms rulings from the 1950s and 60s to the effect that parents do not have a constitutional right to homeschool their children. It also finds that the ruse of enrolling a child in a private school that functions by allowing the children to stay home and be taught by their non-credentialed parents does not constitute instruction in private school. To understand this decision, we begin with the United States Supreme Court's 1968 decision in Board of Education versus Allen. There, the U.S. Supreme Court held that states have a right to refuse to accept homeschooling as compliance with the state's compulsory education statutes. Article 9, Section 1 of California's Constitution states that a general diffusion of knowledge and intelligence being essential to the preservation of the rights and liberties of the people, the legislature shall encourage by all civil means the promotion of intellectual, scientific, moral, and agricultural improvement. Now, in accordance with this constitutional provision, Education Code Section 48200 requires full-time public school education for all persons between the ages of 6 and 18. Specifically, each parent, guardian, or other person having control or charge of the pupil shall send the pupil to the public full-time day school and for the full time designated as the length of the school day by the governing board of that school district. Now, there are some limited exceptions to this rule. The two most arguably applicable to homeschooling would be, one, children who are being instructed in a private full-time day school, and two, children who are being tutored by a tutor who holds a valid state teaching credential for the grade being taught. In this case, the parents argued that they fit within the private school exception because their children were actually enrolled in a private school. But the fact of the matter was that the children didn't attend any private school. They stayed home with their mother, and their mother homeschooled them. They were therefore not instructed in a private full-time day school, and occasional visits by the administrators of that school did not turn the home into a part of that school campus. The filing of a declaration by the parents to the effect that they homeschooled their children because of sincerely held religious beliefs based on biblical teachings and principles didn't make forcing the parents to comply with the state's compulsory public education law a violation of their First Amendment rights either. There was actually nothing fundamental about the faith that forcing the children to attend a real school would violate or destroy. Now, the jurisdiction for making sure children attend school is both in the criminal courts as well as in the juvenile courts. There are criminal penalties for failing to do it, and the juvenile courts can force the parents to do this.